matter of WH Holding Ltd and London Stadium LLP.
Mr. Renovitz.
My Lords, I appear in this matter for the appellant with Mr. Venkateswaran KC, and my learned friend Mr. Downs KC appears for the respondent. Subject to the court, I propose to address 4 topics in my submissions this morning. First, I propose to make some introductory observations about matters that are largely common ground, just to put the appeal into some context. Second, to deal with the legal principles concerning the manifest error exception, particularly in relation to an expert determination that concerns the true construction of a contract. Third, I propose to take the court through the expert determination in this case, because that, of course, rather than the learned judge's judgment, seems to us to be the logical starting point, given that the ultimate question is whether that determination contains a manifest error. And fourth, I will explain why we respectfully submit that the learned judge erred in concluding that the expert determination contains a manifest error. That batting order does mean, my lady and my lords, that I don't get to the learned judge's judgment until my last topic, which is not how one would usually present an appeal, and I appreciate that. But I will, if I may, ask the court to bear with me, because it is necessary first to say something about the law, and indeed the expert determination, in order to explain why we respectfully submit that the learned judge. Can I, at the outset, just acknowledge, my lady and my lords, that in his ruling giving permission to appeal, Lord Justice Mayles expressed some skepticism about ground 1. And he indicated that he would not have given permission on that ground had it stood alone. In fairness, we see the force of Lord Justice Mayles' observation, and we do not therefore pursue ground 1. So we do not say that the learned judge applied the wrong test, but we do say that there are some aspects of the learned judge's reasoning which are inconsistent with the authorities about the concept of manifest error. And I will need to develop that in the course of my submissions.
Thank you. All seems extremely sensible. Just to say, we have had a chance to read pretty extensively and to analyse the expert's determination, the contract, particularly obviously the relevant clause, the examples at the end, and of course the judgment and your skeletons. And I had plenty of opportunity to think about it and the issues. As far as the law's concerned, obviously you must take your own course. I don't understand there to be a huge difference between the parties as to what the ultimate test is for manifest error.
My lord, that's very helpful. I also don't understand there to be a difference as to what the ultimate test is for manifest error. But in our respectful submission, saying that what you have to look out for is a manifest error may not be that helpful, in the sense that one may be assisted by doing for example, Lord Diplock did in the Nemo, where he's dealing with whether something's obviously wrong, by identifying ways in which you can test whether there has been a manifest error. So my purpose of taking you to the authorities is not simply so that you can see that they say, well, you know, manifest error means manifest error, because they don't. They put some flesh on that, and they enable you to test whether what you're dealing with really is a manifest error. We have 4 propositions. I'm happy to deal with this in any which way your lordship.
No, please take your own course, but I just wanted you to be aware that
that's very helpful. And I don't want to waste your time.
You can take things
I don't want
knowing that we all have read everything.
Grateful. And I really don't want to take up time needlessly doing things that you have already done as a court. I do think it would help to say something about the authorities, at least.
No, I'm not for a moment saying you shouldn't.
Well, having had that exchange, can I just first make my first 4 introductory points? And they are very short points, so this won't take up very much time. And indeed, they're all common ground, and there are 4 of them. First, the court will have picked up that the concession agreement in this case relates to the London Stadium and the Queen Elizabeth Olympic Park. And as the learned judge found, this is at paragraph 3 of his judgment, CB tab 7, page 64, the costs of constructing the stadium were met from public funds. as part of the investment in the 2012 London Olympics. That's the first point. The second point is that one of the purposes of the concession agreement was to enable West Ham United Football Club to use the stadium as their home ground. That, for the court's note, is recorded by the learned judge at paragraph 2 of his judgment, page 64. So the position from 2013 onwards was that a football club could use for its own purposes a stadium constructed with public money. Third, as the court will have picked up, it's common ground that clause 20.11 of the concession agreement is what is known as an anti-embarrassment or overage provision. In other words, its purpose is to enable the appellant, E20, as a public body, to share in any gains made by the shareholders beyond a specified threshold. And the court will readily understand the purpose of such a provision, namely to ensure that a public body is not deprived of gains made by a private entity arising at least partly out of the use of a stadium constructed with public funds. Or to put it another way, that the public body is not in an invidious position of having given rights to a private entity, which the private entity then monetizes and makes a profit from, to which the public body in which the public body cannot participate. That's the third of the introductory points. Fourth, it is in this case common ground that there was, in relation to the transaction with which we are concerned, both a sale of 187 shares and also the grant of a call option in respect of a further 1,022 shares. And as the court is aware, the dispute before the expert was whether an anti-embarrassment payment was due in respect of the premium received for the call option part of the transaction. I would note at the outset that, again, as the court will have picked up, it has always been common ground that the option and the share sale were linked, in the sense that neither would have taken place without the other. Indeed, as the learned judge recorded at paragraph 38 of his judgment, that's at page 78, by reference to the terms of the option contract, the premium of £18 million payable for the option in respect of the 1,022 shares was expressly to be paid simultaneously with the acquisition of the 180 shares which had been sold. And just for the court's note, the learned expert also found, this is at paragraph 31 of his determination, it's in the supplemental bundle at page 60, that the shareholders had acted in concert to sell their shares, and that the option was closely linked to the sale and part of the same arrangement. And for good measure, just in terms of the relationship between the two, my learned friend in fact accepted below in front of the learned judge that the sale and the option could be treated as part of the same transaction in a commercial sense. And that, for the court's note, is transcript A1, page 52, lines 15 to 17, supplemental bundle, page 78. So those are the four introductory observations that I wanted to make by way of context, and I'll return to some of them as they matter as regards to particular submissions I'm making.
Can I just check? Is there a transcript today?
No,
I don't remember giving permission for one.
I don't think there is one.
No. Are you going to order one?
If it would help the court, we will order one. Perhaps at the end of the day, you can. If you'd be helped, we will get you one.
Well, it's always helpful, particularly when you're going at quite a pace, which is fair enough. Yeah.
We'll get you my order transcript. I was going to turn next to the second topic, being the legal principles relating to the manifest error exception. And in case the court wanted to see it again, just to note the manifest error, or the rule about expert determination and the manifest error exception, you'll find at clause 50.5 of the contract, core bundle, page 203.
Yes.
Now, as the court will understand, we of course accept that the meaning of manifest error, which defines the agreed exceptions to the results of the expert determination being binding, is itself a question of contractual interpretation. It appears in a contract agreed between two parties, and then, therefore, ultimately, it depends on what the parties intended by it. But as the court knows, it is a concept that has frequently appeared in contracts, and in consequence, its meaning has been considered in a number of authorities. And I don't understand it to be in dispute between the parties that the court can take the meaning of manifest error from what has been determined by the authorities. I don't think anyone is suggesting that there was a special meaning that these parties to this contract had in mind. And so, my lady, my lords, what I wanted to do, if I may, was to summarize our cases to the principles to be derived from those authorities, which I can do in the form of 4 overlapping propositions, and then to take the court to a very small number of authorities to make good each of those propositions. And the 4 propositions are as follows. First, the words manifest error are ordinarily a reference to oversights and blunders that are so obvious as to admit of no difference of opinion. Oversights and blunders that are so obvious as to admit of no difference of opinion. And that is the formulation that one finds, I need to take you to the authority in a moment, in the judgment of Lord Justice Simon Brown in the VEBA oil case, VEBA oil. So
subject to a further qualification of materiality.
Materiality, which is added on, indeed. He adds that on. In fact, he inherits this from an earlier case and he adds on the materiality. That's proposition 1. Second, it follows from proposition 1 that an error is not a manifest error unless it is easily demonstrable without extensive investigation and, importantly, without the need for adversarial argument. And I will take the court to authority in a moment to try to make that good, but that is proposition 2. So an error is not a manifest error unless it is easily demonstrable without extensive investigation and without the need for adversarial argument. Third, I hope you'll appreciate these are all closely related and overlapping ways of trying to put some flesh onto what is meant by a manifest error, at least how you can identify whether there has been a manifest error. Third, if the answer given by an expert to the question he was asked to decide was even arguably right, then it necessarily follows that it was not a manifest error. And fourth, where an expert is asked to make a determination that involves questions of evaluation or interpretation, such as contractual interpretation, then by virtue of the nature of the exercise involved, which is evaluation and interpretation, it is likely to be very difficult to establish that an error is a manifest error. And that is proposition 4. And that may be the reason, my lady and my lords, why there does not appear to be a single reported case before the decision of the learned judge in the present case in which the manifest error exception was successfully invoked in the context of an expert determination concerning the true construction of the contract. So those are the 4 overlapping propositions we advance, and which, as we will seek to demonstrate in due course, the learned judge either overlooked or misapplied. And perhaps I can just take the court to a few authorities to try and make those propositions good.
Yes.
Proposition 1, that's the proposition, oversights and blunders so obvious as to admit a difference of opinion. As I said, that's unlikely to be controversial. It's taken directly from the judgment of Lord Justice Simon Brown in VEBA Oil and was subsequently cited with approval by the Supreme Court in the Sarah and Hussein case. Can I just show that to the court? Authorities bundle tab 4. Now, I'm not sure the facts of the case matter, but in a nutshell, and if the court is interested, I'm taking these from paragraphs 2 to 5 of the judgment. This concerned a dispute as to the quality of certain cargo of gas oil to be delivered under a contract. The contract provided that the cargo was to comply with certain technical specifications and that this was to be tested by a specified test method, and that was called D1298. Clause 10 of the contract provided that the quantity of the cargo would be determined by a mutually agreed inspector at the loading port, which was In the event the agreed inspector determined that the contract, that the gas well did comply with the contract, but in doing so, he had applied a different method, D0452, rather than the contractually specified method, D1298. So he said it complied, but in coming to that conclusion, he applied a different method from the contractually agreed method. The buyer then brought an action claiming damages on the ground that the cargo didn't apply, and the seller said, the seller applied for summary judgment on the basis that there'd been an expert determination which said that it did comply. So the seller brings summary judgment. That application for summary judgment fails, and that is perhaps unsurprising, because, of course, the expert did not follow the contractually agreed instructions. In a sense, what the parties had agreed was to be bound by a determination made in accordance with a particular method, and that method hadn't been followed. So Mr. Justice Morrison rejects the summary judgment application and is upheld by the Court of Appeal in that regard. But because the claim goes off on the basis of the expert not following the contractually agreed instructions, the point about manifest error is not necessary to be determined, and so it arises of it. But Lord Justice Simon Brown nonetheless did make observations about that issue, and those have subsequently been influential. And the court can see that if you go to the final sentence of paragraph 33 of his judgment on page 73 of the bundle, at letter E. And this is in the context, as my Lord Justice Phillips point out, about materiality. But if just looking at the last sentence there, I would extend the definition of manifest errors as follows: oversights and blunders so obviously and obviously capable of affecting the determination as to admit of no difference of opinion. The bit in italics goes to materiality. The bit with which we are concerned does not include the bit in italics because we don't have a materiality point here. That is proposition one, and as the court may have picked up, that formulation was one subsequently endorsed by the Supreme Court in the Sarah and Hussein case. And perhaps I can just show you that authority. It's at tab 17 of the authorities bundle. Again, I don't think the facts of this case matter for present purposes. It concerned a certificate issued by a landlord as to the service charge payable by a tenant under a lease. That, and this is the language of the contract, in the absence of manifest or mathematical error or fault, would be conclusive. If I can then invite the court, please, to go to paragraph 30 in the judgment of Lord Hamlin, who gave the judgment for the majority. It's at page 314, beginning at letter F. And I was going to, perhaps I can just read this to you. It's paragraphs 30 to 34. I don't know whether the court would prefer to read that to yourselves or have me read it.
Why don't we read it to ourselves? I think it is set out by the judge as well, isn't it?
I think it is. Yeah.
And this is also relevant to your second proposition, isn't it?
That's exactly why I'm taking you to it. It not only endorses the first proposition, but it reflects the second proposition. They're all very overlapping. To some extent, it touches on the third proposition as well. because at paragraph 34, it says an arguable error will not suffice. And all of those you could say are captured by the, it ought to be obvious.
But I think I may not have written it down exactly as you said it. Your second proposition was it's easily demonstrable without investigation.
Without full argument. That it's
And
without adversarial argument. I need to develop
I
the
think you said without investigation and without adversarial argument.
and without, yes. I mean,
Extensive.
Extensive investigation.
exactly. Extensive. You're plainly not prevented from people standing up and saying, this is what I say went wrong, and someone saying, well, it's not what went wrong. It's okay.
I mean, this is obviously can be difficult. Lord Hamblin recognises an investigation can be, there can be one.
There can be one, but it has to be short. I can't remember the exact language you used. It's in paragraph
Limited in
32.
time and extent.
Exactly. So I'm not saying you can't look at it, but it does have to leap out at you. It has to be relatively straightforward. I'm going to take you to some authorities which really derive from section 91, section 69(3)(c), which is the Arbitration Act provision.
Yeah.
Something has to be obviously wrong. There are two authorities in that context. It's a very similar question, something being obviously wrong and there being a manifest error. And Lord Diplock, in a case called the NEMA, makes the point about arguability. If it's arguable, if you need argument on it in order to come to a conclusion, then it's not obviously wrong. And what we say one derives just looking even at Louisa and Sarah and Hussein is that for there to be a manifest error, what one is really looking at for are howlers, which is the language that was used by Adrian Beltrami KC in the flow group case which you have at tab 16. That's why one should be able to tell relatively quickly that something's gone wrong. The learned judge in this case did not like that expression, howlers. But in our respect for submission, it aptly summarizes what you are looking for in order for there to be a manifest error.
Mr. Beltrami, but that was a phrase used to him in argument, wasn't
Indeed.
it?
And so that is why we say that the very fact that an adversarial argument is required to decide whether something is a manifest error suggests that it was not a manifest error. I should make clear to the court, and I think the court is onto this point, that so far as we're aware, there's no English authority which draws that particular link between the need for adversarial argument and the manifest error exception. There is a recent Australian case which does do so. It's not a very high authority. It derives that proposition from English authority about an analogous question, which is the section 69(3)(c) point. Can I just show the court the Australian case? It's the expert group decision, which you'll have at tab 18 of the authorities bundle. And if I can invite the court, please, to go to paragraph 150 at page 374. Justice Rees makes some general observations about the concept of manifest error. Manifest error has been described as apparent on the face of the expert determination and reasons, Australian case referred to, or an oversight or blunder so obvious as to admit of no difference of opinion or conclusion obviously wrong and apparent to the judge upon a mere perusal of the arbitral award itself without the benefit of adversarial argument. You see there a reference to Hogbin Tadros, another Australian case. That was a case which relied on Lord Diplock in the Nemo. Again, that wasn't a manifest error case. It was a case under section 69(3). Well, it was pre-section 69(3). In fact, the section 69(3) test is taken from what Lord Diplock said was the requirement in order to get permission to appeal against an arbitration award. Absence of.
How does this work? If an advocate persuades the judge that there's a howler, that's self-defeating because he's had to persuade him there's a howler.
That's true, but it has to be obvious to the judge that it is a howler. I'm not saying you can't It would be
We're
fairly
getting to a number of
self-defeating.
levels of abstraction here, aren't you?
Well, ultimately, one has to have a sense of how much argument you have to hear. If something is obviously wrong, if it admits of no possible dispute that it is wrong, if it is unarguably wrong, even just by looking at it, without being having to be persuaded about it, that certain arguments carry more weight, then you're dealing with a manifest error. If you're dealing with a situation, ultimately, I mean, just cutting to the chase, where there are arguments to be said for both interpretations, the fact that the court prefers, or even strongly prefers, one interpretation, but it needs to be persuaded through argument that that interpretation is right, doesn't mean that there's a manifest error.
Well, that's obviously right, but that's a different question as to whether or not you may be entitled to find a manifest error after argument.
It's quite hard to work out. I mean, I appreciate that you can't rule out argument in order to identify for the court the fact that there is a manifest error. It's really the nature of the argument that we're talking about. If the court listens to argument and requires the argument in order to conclude that there is a manifest error, because there are things to be said for both sides, then you're not dealing with a manifest error. One way of testing it, which is the approach taken by Lord Diplock in the Nemo, was to say that if you look at it on the papers and the error leaps out at you, then you're dealing with a manifest error. If you're looking at the papers and you think, well, I'd like to hear argument about this, then you're not dealing with a manifest error.
But this is rather redolent of arguments about whether or not in days gone by there was a good arguable defence, or was there a real prospect of success, in that you could say, well, if you have to have 2 days of argument of whether there's a real prospect of success or not, then, but at the end of the day, how much argument have to arrive at a particular conclusion, it seems to me, is a rather arid debate. Because if at the end of the day, the judge properly arrives at the conclusion that there is a manifest error, how he's got there, in a sense, by how much persuasion he's taken to find there's a manifest error, can't be a problem, can it?
That may be, with respect, the wrong way of looking at it, because what the learned judge, in fact, what happened in this case, but what should not happen, is the judge looks at the contract and forms their own view about the contract, and then says, well, I form my view, it's different to the expert's view. I think I'm right, therefore there is a manifest error, and I can identify where I think it went wrong.
A fair way of describing what the judge did here.
Well, I'll show you in due course what he did.
I am interested, though, in the proposition, which I think you make full square in your skeleton, that it is wrong as a matter of principle for a court considering whether there's a manifest error to decide, first of all, whether there's an error at all.
Yeah, that's really the point. Once you decide there's an error, you're much more likely to conclude that there's a manifest error, simply because having you can look at this another way. What the parties have decided is that they will be bound by the expert's determination. In other words, they are not actually interested in the court's view about the proper interpretation of this contract. They've agreed that the expert should do it. The only time the court can get involved is to say that the expert has made a manifest error. Therefore, the task of the court is not to actually interpret the contract itself.
I agree that the court's task is not to decide whether it's right or wrong, but the court's task is to decide whether there is a manifest error.
Yeah.
But I don't think you can prescribe that the court cannot or should not, in the course of that exercise, decide whether there's an error. And indeed, it seems to me that before the court can decide that there's a manifest error, it must have decided that there's an error. And if Mr. Downs hadn't persuaded the judge that there was an error, he wouldn't have been able to persuade the judge that there was a manifest error.
Your lordship is right. As a matter of logic, that is right. You can't conclude that there's a manifest error unless you first decide that there's an error. The question is whether that's the right way to go about it. It's not. The task is really to consider not whether there's an error, and then decide whether it's manifest, But just to consider whether, in fact, having regard to the reasoning of the expert, there is a manifest error. That's to say, an error which leaps out at you and is so obvious that it doesn't actually need any argument.
But when a party, these things don't arise in a vacuum. Somebody doesn't magically hand the expert determination to the judge, who, without hearing argument, decides if there's a manifest error. Somebody's got to make an application to the court to say, please set this side aside because there's a manifest error. And they have to identify, in so doing, what is the error which they say is manifest. And it seems to me that the judge, the first thing the judge is going to do is decide, well, is it an error? And it seems to me, in so doing, he might well form a view, well, is that manifest or not? But you may well say, as indeed you do say in this case, it's not an error at all.
With respect, in my respectful submission, that is the wrong way of looking at this. Can I show you two authorities? I understand logically why you say, and as a matter of practical reality, that may well be what has to happen.
Yes.
But you have to have in mind the task on which you're embarked.
Yes.
And the task on which you're embarked is not to interpret the contract and then say, well, I have a different view. Was this a manifest error? But to look at what the expert has done and to say, well, I see why he found that. I don't have to form a view as to whether he's right or wrong, because I see he's identified the arguments. In fact, it's not for me to decide whether.
This is a little bit like saying, well, it's very clear from the highest authorities that when you interpret a contract, it's an iterative process looking at contextual and textual. But it's very clear also from the authority, it doesn't matter which way round you do it. What you at the end of the day is you have to do the overall exercise. And I'm not sure that there's anything wrong in a judge in deciding whether there's a manifest error, starting from the proposition that he has to think if there's an error. And then he decides, if there is an error, is it manifest?
I don't want
There's nothing wrong with that as a matter of logic and
as a matter of
judicial
logic.
approach.
I don't want to spend all my time debating this with you, because ultimately I'm going to say it doesn't really make terribly much difference. But in my respectful submission, that is the wrong way to go around it. You ought to be able to look at what the expert did and to say, I see the arguments. For what it's worth, I probably prefer that argument, but I'm not even going to go into it, because he's done the exercise in the right way. He's considered the arguments. He's come to a particular view. I, as a court, would come to a different view. But actually, unless I can spot an error which is so obvious and requires no argument at all, it's not for me to get involved.
Well, forgive me, but that's really predicating a situation in which you win.
Completely, but you're predicating a situation in which the other side win.
Yes, and in that case, it seems to me that he has to say, beyond doubt, there is an error.
With respect, my interpretation doesn't predicate a situation in which I win. It only predicates a situation in which I win, in which, having done the exercise of looking at the arguments, he says, well, that's obviously wrong. Your reasoning has gone obviously wrong. Your calculation, you're supposed to divide and you've added, or you've taken a figure of 10 where there should be 100. It jumps out at you and it doesn't require arguments.
Well, I understand that, yeah.
It does sort of raises the question as to what an appeal court is doing to get expert determination when it's reviewing a first instance judge's decision as to an evaluative point like construction of a contract. Because it's a different quality of error.
Completely different qualities of error.
Court of appeal differs from one of my decisions on construction. Doesn't mean I'm wrong.
Wrongly differs, indeed. But and that well illustrates the point.
It does, but not.
Indeed, but that does illustrate the point. As soon as it's an interpretive error, it's very difficult to see how it can be said that the error was so obvious that it goes without argument. It's unarguable.
So really, perhaps it's not really helpful to focus on the extent to which you could have adversarial argument. It's whether you can have differences of opinion.
Differences of opinion, indeed. And one goes back to the arguability, obvious error point. And I suppose that the reason about the argument, if you need arguments, that's a reflection of whether there could be legitimate differences of opinion, and no more than that. And just on this, I said before that the line of authority which supports you shouldn't have argument about it, and again, I don't want to get into that, derives from section 69(3), and indeed Lord Diplock's judgment on this. Can I just show that to you? The NEMA you will find at tab 1 of the authority bundle. And this is a judgment which predates the 1996 Act, but which section 69 was intended to codify, the speech of Lord Diplock. The facts don't matter, but if I can ask you to go to page 21. Between G and H, where, as in the instant case, a question of law involved is the construction of a one-off clause, the application of which to the particular facts of the case is an issue in the arbitration, leave should not normally be given unless it is apparent to the judge upon a mere perusal of the reasoned award itself, without the benefit of adversarial argument, that the meaning ascribed to the clause by the arbitrator is obviously wrong. But if on such a perusal it appears to the judge that it is possible that the argument might persuade him, despite first impression to the contrary, that the arbitrator might be right, he should not grant leave. The party should be left to accept, for better or for worse, the decision of the tribunal that they had chosen to decide the matter. Now, that test, at least the body of the test, the obviously wrong test, is incorporated in section 69(3), and that's where we get the point about the need for the benefit of adversarial argument.
Yes, where you get the interesting situation where a commercial court judge has decided, gives leave because he thinks it's obviously wrong, and then there's going to be a hearing.
But there won't be a hearing unless he decides it is obviously wrong.
Yes.
And in a way, we're in the same territory. Manifest error, and it's, I think, Justice Thomas who identified the link in a case called Inverness, which is in the authorities, between section 69 and the manifest error exception, which is why this is a relevant authority. If it doesn't jump out at you, then the court really has no business in trying to interfere with the award that the expert has handed down. Can I also just show you another authority on this? It's the HMV case and Lady Justice Arden's decision in that, which you have at tab 8 of the authorities bundle, page 150, paragraph 34. Just to set the problem, it's bottom right-hand corner. I now turn
Sorry,
to...
forgive me, which page?
150.
Thank you.
I now turn to my conclusions, bottom right-hand corner. As I see it, this is primarily and above all an exercise to ascertain whether the arbitrator's approach was one which could properly be described as obviously wrong for the purpose of section 69(3). So that's just setting the scene. If we can then pick it up in the penultimate sentence of that paragraph over the page, halfway down, I take the view, 6 lines from the end of that paragraph, I take the view that the interpretation to which the arbitrator came in this case was one which did not meet the test of being unarguable or making a false leap of logic or reaching a conclusion for which there was no reasonable explanation. I am not therefore able to conclude that this conclusion was obviously wrong. So those are the first 3 propositions, and you can see that I rely mainly on the Nemo line for the discussion about whether you need oral submissions in order to establish the point. Proposition 4 is not about the concept of manifest error generally, but you'll recall it's about the application of the manifest error concept to a determination about the true construction of a contract. And we do say that it is inherently more difficult to establish that there was a manifest error in this error, given the nature of the evaluation or interpretation that the exercise involves. And importantly, my lady, my lords, the fact that the expert departs from what the court ultimately considers to be the clear meaning of a contractual provision does not necessarily mean that there is a manifest error. So the fact that at the end of the day you say, well, he was wrong, she was wrong, and I'm clear about that, doesn't mean there was a manifest error. And that follows from the three propositions I first identified. To be clear, we don't say that it is impossible for the interpretation of a contract to disclose a manifest error. One can easily imagine situations where it would, for example, where you have a contractual formula which requires the expert to multiply and instead she divides, or where there's an obvious error in the arithmetic, or where the formula requires a particular multiplier and the expert chooses the wrong one, puts 10 instead of 100. Those are easy examples, and each of them are both obvious and capable of demonstration without the need for adversarial argument. In short, you're dealing there with a howler. But if, by contrast, what the expert has done is resolve a dispute about the meaning of a contractual provision involving some tension between the text of the provision and what the expert reasonably understands is its commercial purpose, or perhaps some tension between the text of different provisions of the same contract, then while it is plainly still theoretically possible for the expert's determination to involve a manifest error, in practice that is unlikely to be the case because of the high threshold and the requirement that the error must not only be obvious, but be capable of demonstration without the need, what has to be unarguable, without the need for adversarial argument.
You gave some fairly obvious examples, like a mistake in a formula. It might be possible, mightn't it, for the expert to go wrong in the way they carry out the exercise. So, for example, if they give an entirely literalist approach, interpretation
Indeed.
of words, ignoring context.
Indeed, indeed. What we obviously have here is the exact opposite thing being said, that he should have given an entirely literal meaning to a particular word. And indeed, there's another case called Walton House, which is a judgment of Mr. Justice Peter Smith, from which permission was refused by Lord Justice Kitchen in a reasoned judgment, where again, you have the expert refusing to give a literal meaning to a provision. Party says, well, that's obviously an error because the provision's very clear, and the Court of Appeal in Walton House says, no, he's obviously entitled to take into account purpose, and that's not a manifest error. There's a tension between the two, and he's just chosen to emphasize one rather than the other. But my lord is right. It is possible that the approach which was taken reveals a manifest error. Now, as I say, we say that the fact that the court ultimately concludes comes to a different view, and a clearly different view on the contract doesn't mean that there has been a manifest error. Now, my learned friend at paragraph 11 of his skeleton advances what appears to be the opposite case. He does it by reference to what he calls an unambiguous provision. In particular, what he says, this is at paragraph 11, page 46, if the court wants to see it, is that if a particular contractual provision is unambiguous and the expert's construction of it differs from the court's construction of it, then there is automatically a manifest error. But as the court will note, the learned friend cites no authority whatsoever for that proposition. It may be, Lady my lords, that this is a point which doesn't actually arise on the facts of the present case, because we submit that the relevant contractual provision, as I'll seek to show you in due course, is at a minimum ambiguous. But putting that to one side for the moment, we would respectfully submit that my learned friend is wrong about that. In particular, as the court will know, it is not uncommon in disputes about contractual interpretation for each side to say in relation to a disputed provision that the clause in question is unambiguous and unambiguously in their favour, but for opposite, in other words, for opposite purposes. Nor is it uncommon for the court in the event to find that the provision is unambiguous after have a hearing argument about it, and only after hearing sustained argument and indeed detailed analysis. The mere fact that the provision is ultimately found by the court to be unambiguous after extensive argument and perhaps an appeal does not mean that an expert who adopts a different construction of it has made a manifest error. Now, before I move off the law relating to the concept of manifest error, can I just show you one further authority which we would draw to the court's attention as a useful illustration of what we submit as the proper approach to be adopted by English law to this question. And that is the decision of Mr. Justice Peter Smith in the Walton Homes case. I'm taking you to this. I appreciate it's the first instance judge, but as I say, it was reasoning which was supported by Lord Justice Kitchen, albeit in refusing permission to appeal. You have that at tab 10 of the authorities bundle. The case concerned a contract for the sale of land, and that provided that additional consideration would be payable if the purchaser or an associated party were to obtain planning permission for the property, thereby increasing its value. So you have a sale at a particular price, but if planning property is obtained, then there'll be an increase in value. There, as here, there was an overage provision. That's to say, you will have to pay more in due course if there has been planning permission. And the purpose of that was to ensure that the seller could share in any profit subsequently realized by the purchaser in the event planning permission was obtained. Now, one sees the formula for calculating the overage payments quoted at paragraph 15 of the judgment of Mr. Justice Peter Smith. You'll find that at page 178. Clause 5.4, just picking it up at the 5.41, the assurance of the property to the buyer shall also contain the following development value clawback provisions for the benefit of the seller. And then one subclause 3 of this clause shall apply if at any time during a perpetuity period of 80 years from and including the date of this deed, if either the buyer or any successor in title in respect of the whole or any part of the property secures any planning permission for the carrying out of any development of the property. If you then drop down to subparagraph 3, if this subclause applies, then within 1 month of the occurrence of the relevant contingency set out in subclause 1 of this clause, the buyer or its successor in title shall serve a notice on the buyer to inform the seller of the granting of the relevant planning permission. And you see the definition of the permission. And then going down to C, stating the sum which in its opinion acting reasonably represents the difference between the following two values determined as of the date of the service of the notice. Firstly, either, whichever is the greater, the open market value of the property, assuming that the permission does not exist. I'm not sure we need to be concerned about the rest of that. And then little 2, secondly, the open value of the property with the benefit of the permission. So comparing two figures, one with the permission and one without the permission. And just have in mind that the way permission is defined is by reference to the granting of the relevant planning permission. Now, if I could then invite you to go, please, to, just to emphasize that point, as you see, it was defined as the actual grant of the permission, not the preparatory stages for the grant of the permission. So you only look at the actual grant of the permission. If I can then invite the court to go to paragraph 25 on page 182. Here the learned judge is looking at what the expert found. He was a Mr. Tanny. And the court sees there that the expert concluded that the literal meaning of the defined term permission was the formal planning decision notice. So the expert looks at the definition and says, I see that it relates to the actual issue of planning permission, but the expert nonetheless concluded that this literal construction was to be rejected because it didn't make commercial sense. And you see that at paragraphs 26 and 27 on this page. So just picking that up, he expresses the opinion that permission relates to the literal meaning He rightly observes that the argument is over the phrase, assuming that the permission does not exist. He set out the varying submissions, in particular Walton's submission that these words require the surveyor to ignore the existence of the valuation date of the planning permission itself, but not to ignore other matters relating to planning permission, in particular not to ignore the recommendation of the planning officer that planning permission should be granted, and thus also include a large element of planning gain, meaning that the difference in values 1 and 2 for the purpose of the agreement would be commensurately small. He disagreed with Walton's analysis. He set out his reasoning at paragraph 18, where he says, I do not consider Walton Holmes' ultimate contention is correct. This is because Walton Holmes' contention that my instructing surveyors to ignore only the planning permission, but must take into account the planning officer's recommendation, which I've outlined above. As I've said, I consider the literal meaning to be reasonably clear. However, I consider the context of the TRI as a whole. The court would not give effect to that literal meaning. The argument appears to have been that what, by the other side, the expert having rejected this, you only need to ignore the planning permission, but you should take into account in stage 1 everything prior to that, including a recommendation that planning permission should be granted. Now, if you do that, there's going to be no difference between the two values. And the experts there said, well, I'm not going to do that. I appreciate what the literal meaning is here, but it gets me to an uncommercial result. And if I could then invite you, please, to go on and I should just say, before I go on to any of the other paragraph, that is similar to what has happened in this case. Malone & Friends clients want to refer you to the language in the consideration definition, and in particular the or word, and they want to say as a result of that, you need to get to a particular result whereby if you have a qualifying transaction which has 2 elements, you have to, when valuing each element, ignore the fact that there's another element. And that, the experts found, produces a result which just could not have been what the parties intended. So it's not dissimilar. If you then go to paragraphs 39 to 40 on page 187, this is dealing with the submissions of the developer, who had argued that the expert had made a manifest error because the words were unambiguous and could not be supplanted by commercial common sense. To paragraph 39, he submitted that there was no clear indication that something had gone wrong with the language and that it should be clear what a reasonable person would have understood the parties to mean. It is said there is no such lack of clarity. That then he submitted this entitles Mr. Taney going on to the next stage of the reasoning and applying what he said basically was commercial common sense. And if I can invite you next to go to paragraph 43 over the page. If I were being asked to construe the agreement, I can see some force in these submissions. However, I'm not being asked to construe the agreement. I'm being asked to determine that the decision of the surveyor in light of Mr. Taney's opinion contains a manifest error. This means that Walton must establish not only that the reasoning is wrong, but is manifestly wrong. And then paragraph 46, however, it is impossible, in my view, to say that the reasoning is manifestly erroneous. To my mind, Walton's submissions are classic examples of every mistake becoming manifest when it's discovered. Manifest is a word which gives a very limited window of opportunity to challenge. The examples given in the various authorities above show that it is something like an arithmetical error or a reference to a non-existing building and the like. There is nothing manifestly wrong about the decision of Mr. Taney. This is well illustrated, demonstrated by the fact that the competing arguments put forward in this case were, in my view, very strong on both sides. This is not merely a situation where a dispute is created so as to lead to a suggestion that it cannot be manifestly wrong. There was merit and is merit in both sides' arguments. The parties by the agreement gave the surveyor the power to determine that decision in law and in fact. I do not see that his reasoning provided as set out above is manifestly erroneous. It might be wrong if one was pressed to argue it, but that, as I've said, is not sufficient. It does not look obvious when reading his analysis. It is not obvious that he is disentitled from looking at the factual matrix out with the 4 corners of the agreement. It is not manifestly erroneous to do that because the limited construction put forward by Walton produces a commercially absurd result. It is not manifestly erroneous for him to apply the principles in Chartbook and apply that to the words the permission and come up with a wording that which reflects the intent, namely that the parties were to share equally in the planning gain obtained in respect of the site. It is not intended for the planning gain to be largely pocketed by Walton, which is the logical conclusion of the application of the literal words of the agreement. As Lord Hoffman said, something must have gone wrong. These are perfectly acceptable reasons for his conclusion. they're not manifestly erroneous. Now, permission to appeal Mr. Justice Smith's decision, Peter Smith's decision, was refused, as I've said, in a reasoned judgment given by Lord Justice Kitchen, as he then was, and we have that at tab 11. I can just show you paragraphs 17 and 20 of this, which you have at page 195. Before that, he's setting out the background. These are the principles which Mr. Tanney applied in his opinion and which the surveyors adopted in his determination. They involve no error of law, although I do accept that there was certainly room for argument as to the result the application in the context of the present case should have produced. That was something which Mr. Tanney considered with considerable care, as did the judge in his decision, the subject of this application for permission to appeal. The judge reached the conclusion that whether Mr. Tanney was right or wrong, it could not be said in his opinion that it was manifestly wrong. It necessarily followed that the same applied to the determination of the surveyor. In my judgment, this was right. A manifest error is one which, as Mr. DeWall submits, is so obvious as to permit no difference in opinion, one that is obvious or easily demonstrable without extensive investigation. And then just looking at paragraph 20, right or wrong, and Mr. DeWall has advanced the most persuasive submissions to me this morning that it was wrong. Mr. Tanney's conclusion is, in my judgment, certainly not manifestly wrong. I've reached the conclusion that this application should therefore be dismissed. So that, we submit, represents the approach that the court should take. If there are arguments, you don't go on to decide, well, I see the arguments, I'm going to work it out for myself, and then conclude, well, I'm clear, having heard argument, that it was wrong, and it was manifestly wrong. You just say, there are arguments both ways, I'm not going to get into this. Can I then go on to the second point, which is the expert determination? And can I invite the court to take that up, please? Supplemental bundle, tab 7, page 52. Now, Lord Justice Phillips indicated that the court has been through this, and I'm going to therefore take this relatively rapidly, if I can. The reason I want to do that is really because the court has my submission that the error must really leap out from the reasoning without the need for extensive investigation or argument. And so one needs to understand what that reasoning was to see whether the error leaps out. If I can invite the court, please, to go to page 53. You see, the court sees that the expert begins by recording the background facts, which is in notice paragraph 2, were and are undisputed. And as the court will have picked up, and this is set out in paragraph 5, purchaser 1890 Holdings acquired 187 shares from the shareholders identified in paragraph 5A at a price of £138,162 per share. So that's about £25 million in total. And in addition, as you see, as noted paragraph 5B, the purchaser was also granted a call option by Mr. Sullivan in respect of a further 1,022 shares, and the premium paid to Mr. Sullivan for that option was £18 million. And you see that recorded paragraph 7A. So just pausing there, this is a transaction in which the vendors received not only £25 million for the 187 shares that they sold, but they also received a further £18 million for the shares in respect of which the option was granted. If I can then invite the court to look at paragraph 10 on page 54, the court sees that the expert notes that there was no dispute about the stadium premium amount due in relation to the 187 shares, although in fact even that had initially been contested. By the time they got here, it was not. Then going to paragraph 12, page 55, the expert observes that the dispute was about the £18 million paid for the option and whether that should be taken into account in calculating the sums due. Then just reading on, as the court sees beginning at paragraph 13, and really going on all the way to paragraph 19, the expert identified and for the most part set out the relevant provisions of the contract And I don't understand it to be suggested that he didn't include any relevant provision of the contract. And then at paragraph 25, on page 58, the expert identified the issue between the parties. Just looking at what he says there, as noted above, the issue between the parties is whether the transaction for the sale of the 187 shares and the grant of the option for £18 million amount to a single qualifying transaction. The grossed up consideration for...
Just pausing there, he said at paragraph 12 that there was no dispute that was the issue. The issue between the parties, as expressed in this court at least, seems to be rather different, potentially rather different. As I read the expert determination from paragraph 12, he treats the issue as whether there's one or more qualifying transactions.
I understand what your ladyship has in mind, because there is also this point about whether you can blend, which is the way my learned friend puts his case. But the primary issue, and indeed the blending question, does depend upon whether you can have a qualifying transaction which has two elements in it.
I think that may be another way of putting what I'm saying, but he treated that as the core.
And with respect, that is still the core issue. Because although the learned friend really has two arguments. His first argument is that when you look at the definition of qualifying transaction, you also have to have in mind the definition of consideration. And there's a kind of flashback effect, because he says if you look at the definition of consideration, qualifying transaction cannot mean what the expert says, I cannot include two things. That is, in my respectful submission, still the main point he makes. He has a second point, which is to say, if you are going to include more than one element in the definition of qualifying transaction, you run into a problem, because there is no mechanism in the contract for blending, I think the way it is put, the two elements in order to produce your stadium premium amount. But the question is still, does that mean you can't have more than one element of a qualifying transaction? It's a further argument against there being more than one element of a qualifying transaction. So my learned friend runs both those arguments in order to establish his case, which is you can only have one element in a qualifying transaction.
There's no dispute that the expert defined the issue before him.
No, they don't.
There is a dispute about that, and I made it clear to the experts in the note of the hearing for the expert. Double counting point is a freestanding point. I'll show you, Lordships.
Well, with respect, my learned friend's wrong about that, and I say he's wrong about that because if you look at, I'm not going to invite your Lordships to go to this. If you look at my learned friend's respondents, it's not only not in the respondent's notice, it was also not pleaded in the Part A claim form that the misunderstanding extended beyond the qualifying transaction point that I've just made. And I'll show you in due course what was said to the learned judge about this as well, just so that we're clear about the two manifest errors which it is said was made. I'll come to that in due course. But I just want to cut to the chase, which you may be pleased about. That is what my learned friend says and said to the judge. The expert got wrong. That there were two arguments as to why you couldn't have more than one element of a qualifying transaction. So the expert considered that produced an uncommercial result. Because effectively what it means, let's say you have a contract whereby the parties, same parties, agree in one provision that there'll be a sale of, doesn't matter how many, 1,000 shares at a particular price. And in the same contract, they have an option agreement for a number of other shares. And they could have structured the contract in a way so that you have, they want to actually sell. You could have an option which is exercised 3 days later for the other half of the shares which are going to be sold. In other words, the idea is to sell 100 shares, but what they do is 50 shares by way of a sale, 50 shares by way of an option. It's exercisable for ultimately consideration for the grant of the option is the same as for the sale, and then there's a £1 exercise price. So they split up, instead of having a sale of 100, they split it up in two. In my learned friend's case, although there has plainly been a sale of 100 shares commercially, His case is you should evaluate and run through the ratchets, each of those things separately, so that you will never hit the threshold amount, because each could be less than the threshold amount in circumstances where the commercial reality is you are disposing of the shares under the option and the shares under the sale agreement. And that's what this is about. I'm not saying that's what my learned friends did in this case, but that's the effect of his interpretation. And that's what the expert did not like. The expert did not like the idea that what you could do was have a transaction, plainly a qualifying transaction, in which you split up the sale, the amount of shares which are being sold. You could actually split up into two elements of a sale, one at price A and the other at price B, or you could do it by way of an option. And by so doing, you could structure around the application of the payment of the stadium premium amount. We just thought that was commercially absurd.
Can you show me where does the expert say that?
He doesn't use the language I'm using. He doesn't, but you can see that is what he has in mind.
What do you rely on for that?
I'll show, if I can just take you through it, I'll show you that.
We haven't looked at the contractual provisions themselves, and I'm not sure you're going to.
Well, I was going to show them to you, yes. I'm going to show you.
But it seems to me that the contractual provision is problematic insofar as C deals with option, the price of the option, rather than the price of the shares, because it does not, the price paid for the option usually will not give you an equivalent price for the company, the value of the company, and so you are to a large extent considering apples and pears, aren't you, when you are doing the exercise?
Well, it's the price paid for the on the basis of consideration paid for the shares sold, or the consideration to be paid for the share option. So it does include both. Has an or between them.
Yes, it does, but that's assume that we're only looking for a situation where it is the price of the option.
That is, with respect, that is true. You might, but take the other situation. Let's say you're dealing not with a pay. Let's say there is a price payable for an option, for the grant of the option, and also a price payable for the shares when the option is granted.
Yes.
That's all dealt with under C. Now, it may not be elegantly done, but take the situation where the price, where you're looking at a price payable for the grant of the option, because the option, person can exercise the option 3 days later and pays a particular price. On my learned friend's interpretation, even though the same amounts are paid by the same people to the seller, you don't take them into account at the same time. You price them up, you evaluate them separately. And you therefore do not achieve, effectively it means you can draft around and avoid hitting the threshold amount. I can give you an example if it would help, but I think you have in mind.
Well, because it's a completely different thing, if there are actually shares sold, then it isn't so problematic, is it?
With respect, it still is problematic, because you could take two sets of shares sold in the same transaction, albeit at slightly different prices, and you still have the blending problem, and you still have two transactions in a qualifying transaction. With respect, on my learned friend's case, you would still not be required, you'd still not be able to take into account both elements of that qualifying transaction.
But if you just simply add them together, it becomes a perverse result, doesn't it?
Well, I'm not sure that the result's perverse, but as I say, you have the same problem if you'd have two elements, both of which are sales, as long as they're not for identical terms.
It seems to me that there's a certain logic in, we can see the sense in saying, well, if you get the option price, but no shares are sold, that's an extra consideration that is being received by the shareholders, and it's perfectly sensible that that should be factored into the shareholder premium. They've received an extra 18 million,
Right.
And why shouldn't that be included? But if they do actually sell shares, at a price, which equates to a value of the company,
Right.
why should it simply be added on? Why should they get double the premium?
I'm not sure they get double the premium.
Well, whatever the amount would be.
You would add both amounts on, because ultimately, ordinarily, what you would have is an option. You'd work out how much the strike price for the option is and how much it could be exercised at, and the two together would equate to what you regard the value of the shares as being. In other words,
I think
not always.
I think one of the problems is it doesn't equate to a current market value, and you can see that with the option premium and exercise price. The reality is that commercially you can't, as my lord says, extrapolate purely from an option premium to work out the value of the company. Nevertheless, that is what the formula
Does.
requires,
Exactly.
and it's not certainly not our
No.
role to.
Indeed. And this may be imperfect. It may be imperfect, but it's what the parties agreed. And the issue really is not so much whether it was a good idea or a bad idea to have the bit dealing with options structured in the way that they did, but whether in circumstances where a qualifying transaction plainly has two elements, is it really the case that you have to run them through the ratchet separately and therefore allow for the possibility that although the seller has achieved an amount well above the threshold amount, he avoids hitting the threshold amount simply by splitting the transaction into two elements. And as I say, it's important to have in mind, it doesn't only, that problem arises not just when you have a sale and an option, it arises also where you have two sales in the same transaction at slightly different prices. So that is ultimately the issue that arises.
If one looks at consideration item C on page 57, the wording at the start, if any share purchase option or similar in the club is being sold in that qualifying transaction, that on its face seems to suggest that you can have a share purchase option as one element of a qualifying transaction.
It does. In my respectful submission, other than the "or" word, which I suspect doesn't have the weight or the force that the judge and Malone think it has.
But it doesn't matter to you if you can have, if C is dealing with a case where you have a share purchase option and other elements such as sale, then the or point disappears, doesn't it?
It does disappear. My lord, with respect to, is right about this. That is why we do submit that the learned judge was actually, sorry, the expert was actually right, but certainly he wasn't unarguably wrong.
But just whilst we're on it, where does one get from that clause, or indeed anywhere else, the suggestion that what you do is add together the results of B and C?
I have to hold up my hand and accept that there are arguments against what the expert did, and that is one of the arguments, which is to say there is no expressly set out mechanism for what you do if a qualifying transaction consists of two elements. But what I say is that there are arguments the other way as to the fact that you really ought not to be refusing to have regard to the possibility of two elements. And if you do have two elements, you have to do the best you can, which is what the learned judge.
And one of the difficulties is, isn't it, that you've put the option price at the end, whereas it could go at the beginning. And if it went at the beginning, it would mean that the price was lower?
My lord is right. There are different ways of doing it, and you're absolutely right to say there are arguments against what I'm contending, and indeed what the expert concluded. The question is not whether there are arguments against it, but whether there are no arguments in favour.
Yes, I understand that. Just, at the moment, just trying to understand what the scope of all this is.
Okay.
Because as I understand it, what it means you accept that there is no express or no express provision here that as to how you deal with two elements, different elements of the transaction, and also there's nothing to say in what order you deal with it, and obviously order matters here.
There isn't. This is definitely not a perfect contract.
So what did the expert decide in that regard? I don't think he decided anything, did he?
Well, I think he was given a calculation by...
He decided that you were right.
And he decided that that calculation was correct.
Is it fair to say that it, because as my lord says, there are different ways of doing the calculation, even if you combine the elements, and it would produce a different number. But my reading of what the expert was asked to do and did is that he wasn't asked to decide between those numerical alternatives. He was asked to decide the principle of whether you combine the figures.
Correct.
And he wasn't presented with alternative calculations. Now that may have been because the figures were already agreed for the share sale element.
Or that my learned friend was putting his argument on the basis you shouldn't be doing this at all because of the word "or."
But it strikes me as it's quite important to understand what the dispute was that went to the expert.
Which goes back to my lady's point earlier about whether the dispute really was about whether the qualifying transaction was whether you could have a qualifying transaction which included more than one limb, having regard to the definition of consideration. And I'm not trying to brush away my learned friend's second point about blending, because the point is a fair one, but it goes to whether the same point as to whether you can have more than one element of qualifying transaction, because in my learned friend's case, that is an indication that you can't have more than one element. Once the expert concludes, as he did, that would effectively, he takes the view that you can have more than one element of qualifying transaction. He then does add them together in a way which, in my respectful submission, is entirely logical. It makes perfect sense to do what he did. And I don't dispute that if you started in a different way, you may get a different result. But as my lady says, there's no dispute about that before the judge. It's true, you can get a different result. Can I just continue, just because I'm conscious that I only have less than half a day. So I've shown you paragraph 25. I think I've shown it. Maybe I didn't show you paragraph 25. I think I was about to. The issue between the parties is whether the transaction for 187 shares at the grant of the option quality amounted to a single qualifying transaction, and then the gross consideration for the option equates to 60 million, i.e. the equivalent of 18 million for 1022 shares grossed up to 3,438 shares. 60 million is well below the threshold of 125 if the option agreement is not treated as part of the same qualifying transaction as the sale of 187 shares. On that basis, no stadium premium amount would be payable in relation to the 18 million for the option. If the 18 million option payment is treated as being part of the same qualifying transaction as that of the sale of 187 shares, then a stadium premium amount of 3,600,000 is payable as the adjusted consideration, no actual adjustment being required, as the adjustment was made in relation to the adjusted consideration of 187 shares is subject to the formula provided by the agreed percentage amount 20%, as the adjusted consideration for the shares and the option is in excess of 300 million, which amounts to 12 million, and then prorates back to that. So
that's where he just makes the assumption that if it's part of the same qualifying transaction, then this follows. Which is
because you have to add them together.
And he's assumed that you add them as you have put forward in your proposal.
He proceeds on the basis that you should add them as we put on the proposal. And I can take you through what he did. how he did it, but it does, what he did, looking at it, is completely unobjectionable if you take the view that a qualifying transaction can have more than one element. Now, at paragraph 26, he summarises my learned friend's case in terms that I don't think it is suggested is inaccurate in any way. That was and is the construction for which my learned friend contends, and it was correctly identified by the expert. Then at paragraphs 27 and 28, he refers to the principles of contractual interpretation. Again, I don't understand it to be any suggestion that he has these wrong. And then at paragraph 30, he records my learned friend's submission that there are 4 qualifying transactions rather than 1. And in the final sentence of paragraph 30, the expert appears to reject that submission. That submission assumes that the expression any means only one only, I is a limiter as opposed to all or every or one or more. And in reliance upon that construction contends that the expression qualifying transaction cannot comprise a number of separate contracts even if they are affected at the same time and are coordinated with each other and part of the same contract or arrangement. And then at paragraph 31, he records that the relevant shareholders acted in concert, and the court has seen that. And then can I invite you please to look at paragraph 32 and perhaps read that to yourselves, page 60. And so the reason I draw the court's attention to that paragraph because it shows that the expert was alive to the fact that the main argument advanced by the learned friend concerns the definition of consideration, and in particular the contention that elements B and C cannot both apply to the same qualifying transaction. And then the expert identifies between paragraphs 33 and 35 the submissions made to him by the parties, and the court will then find the expert's determination in 2 key paragraphs. That's at paragraph 36 and 37. And again, if I can invite the court to glance at those 2 paragraphs. And the court will particularly look at the expert's reference to the purpose of the contract. So the learned judge concludes the expert concludes both that there is nothing in the language which in effect prevents him from giving effect to what he takes to be the purpose of the contract, having regard to the nature of, or the intended nature of the payment of the overage payment. And one of the things I'm going to show you, which is interesting about the learned judge's approach, is he says nothing at all about commercial common sense or purpose. He simply looks at the language, at the word "or" in particular, and the fact that there isn't, as he sees it, any express language dealing with the blending. And so if anyone, with respect, is guilty of taking an approach which is not in accordance with the authorities, it's actually the learned judge. It doesn't have regard to the commercial context and common sense, whether this could have been what the parties intended. And that, I think, is a neat segue onto moving off the expert's decision and onto decision. I'm going to show that to you in a moment. But we do say, before we get into the detail of what the learned judge said by way of concluding that there was a manifest error, that there are two, or at least one overarching point about why the conclusion reached by the learned judge was unlikely to be correct. And that is, we would submit, because it is apparent simply by reading the determination without looking at anything else, that what the expert had to resolve was a familiar type of dispute about the meaning of a contract, namely a dispute in which one party says that the words are clear and unambiguous, whereas the other party says that they are not and seeks to rely on factual matrix or commercial common sense in identifying the true meaning of the provision. And it comes to a particular conclusion. Now, that is by way of a gross generalization what a great many disputes are about in relation to contractual interpretation. And that this is the nature of the task in which the expert was engaged is, we suggest, apparent, despite the fairly brief nature of the reasoning, in particular from paragraph 27, where the learned judge identifies the commercial purpose of the overage provision, that's at page 59, as well as from paragraph 36 at page 63, where he considers the language and concludes that it's not a misuse of language to describe two separate but linked agreements as part of one transaction, and also from paragraph 37 at page 63, where he considers another linguistic point made by my learned friend relating to the word any, and also in the final sentence of that paragraph, where he refers to the linchpin of my learned friend's case, namely the definition of consideration, but explains that in his view, each of B and C can apply to different components of a single qualifying transaction. So we say that this is very far from a case in which it can properly be said that the expert has made a howler. In our respectful submission, the conclusion reached by the expert, we respectfully submit, is right. And if it's not right, it's not unarguably wrong, I can put it that way. The second point I was going to make before we look at the judgment is this. As the court knows, the expert's taken one view of the contract and the learned judge below has taken a different view. And thereafter, following the decision of the learned judge, Lord Justice Males gave us permission to appeal because he was satisfied that the appeal had a real prospect of success. And perhaps we might just briefly look at Lord Justice Males' permission decision. You have that in the core bundle, tab 9, at page 92. So just looking at paragraph 1, grounds 2 and 3 are arguable with a real prospect of success. In particular, it is arguable that the expert did not make a manifest error in concluding that the share sale and call option were both part of a single qualifying transaction and that the definition of consideration, despite the disjunctive or, had to be applied to each component of the transaction. Now, my lady, my lords, I don't wish to overstate the significance of this. Because, of course, as the court sees, what Lord Justice Males is saying here is that he considers it's arguable that the expert did not make a manifest error. Of course, if Lord Justice Males had instead said that it is arguable that the expert's construction of the contract was actually correct, that would be different. Because that would suggest that there was an argument about whether he was correct, which means it wouldn't be a manifest error. But he doesn't say that. He simply says it's arguable as to whether there's a manifest error, and I accept that the two are not the same. But we do say that the fact that the expert, an experienced commercial silk, adopted this construction of the contract, and that Lord Justice Males was, on a perusal of the papers, persuaded that permission to appeal should be given, on the basis that it is arguable that the expert did not make a manifest error in his interpretation of the contract, do serve to reinforce what we would respectfully suggest is apparent from the determination, namely that whatever the contract actually means, the expert's analysis is not manifestly wrong. I'm not going to put, it's not a party trick, it's just a point. It doesn't really take one
I
much
don't really
further.
understand the point.
I beg
We're
your
only
pardon?
hearing your appeal, which we might reject, because Lord Justice Males gave permission because he thought it was arguable. So I'm really not sure where you
If
get
he-
anything from it.
I'm not sure that if your lordships conclude that I'm right in what I'm saying, then Lord Justice Males is what he thought doesn't actually help. If you conclude I'm wrong in my submissions, then again, you're not going to be persuaded that you should change your mind because of Lord Justice Males, what Lord Justice Males said. So I accept there's not much.
All he's saying is that your entire is what you are arguing to us is arguable.
Indeed.
So I'm not sure where it advances.
I'm not sure it takes you very far. I think my real point was, if what he had said, which he hasn't said, if what he had said, which he hasn't said, is that it's arguable that the expert was right, I would be in a better position. Because there would be someone saying that it is arguable that, but you don't have to agree with that either.
Lord Justice Mayors always chooses his words carefully.
Let me move on to what the judge in this case did. I'll just take you through his reasoning and explain why we respectfully submit he was wrong to conclude there was a manifest error. The court knows that the judgment is at tab 7. Page 63. The learned judge turns to consider the law relating to manifest error at paragraph 18, page 67. And that runs through to paragraph 27 on page 72. And the learned judge here identifies the main relevant authorities, including Weber and Sarah the same. So he certainly identifies the authorities, although, as I identified at the outset, we don't say he dropped ground one, so we don't say he wasn't aware of the test, but we do say he, when it came to applying the test, he didn't apply it correctly. Can I then take your lordships and your ladyship to where we say the court went wrong here? If I can show you the individual reasons the learned judge gave for concluding that there was a manifest error. I might just first show you paragraph 29, if I might, because it does suggest, in our respectful submission, something slightly wrong with his approach. If you look at paragraph 29 on page 72, the learned judge says there, having regard to the guidance in Sarah and Hussein, in my judgment, my consideration of these materials cannot amount to impermissible extensive investigation. It is rather investigation of the type that the parties must be taken to have agreed could take place in the event that one of them challenged the outcome of a reasoned expert determination on the basis that it contained a manifest error. It is also relevant, in my judgment, that there was no possible remedy for an aggrieved party other than by challenging a determination on the grounds of manifest error or fraud. A fairly thorough examination of the expert's determination is consistent with the fact that this would be the one and only chance of avoiding its consequences if they were indeed affected by the error. And just two comments on that reasoning. The first is that the learned judge plainly thought it was appropriate to undertake a fairly thorough examination of the expert's determination. And the court may wonder whether that is consistent with the approach to manifest error which is established by the authorities of saying it should be readily apparent. The second is the learned judge seemed to think that that approach was appropriate because the challenge to manifest error would be the one and only chance of avoiding its consequences if there were indeed an error. But with respect to the learned judge, that is the wrong way of looking at this. The question is not how you can challenge a decision, or whether this may be your only chance to challenge the decision. The way one needs to look at this is, in fact, to say the parties agreed to be bound by the expert determination. And that ordinarily you would expect them to be bound, and that there shouldn't be a challenge, save in the very narrow circumstances of there being a manifest error as identified. And we do respectfully submit that the learned judge, when he came to analyse the determination, did mislead himself in terms of his approach by what is identified at paragraph 29, that he thought this was the only way in which you could get out of this decision, and therefore it was appropriate to undertake a fairly thorough examination of the expert's determination, because otherwise you might be bound by a decision that he thought was wrong. With respect, as I say, that is simply not the right way round. Now,
is that a replacement argument to the ground one that you're not pursuing? Because you haven't identified this as a ground of appeal.
My Lord, you may be right. We haven't identified it. I'm not sure it's a separate ground. I'm saying that it feeds into what he did by way of an approach, and it is manifested in the errors that we say he did actually make, because he did adopt he understood what the test was. It's just that when it came to apply it, he didn't apply it in the way that he should have applied it. Can I then just invite the court to go, please, to paragraph 63 at page 83. At paragraph 63 on page 83, as the court sees, the learned judge identifies the two manifest errors pleaded by the respondent. He took them in turns, and I propose to do the same. But just to identify what they were, first error, the expert has accepted E20's calculation of the stadium premium amount, which was arrived at by applying the percentage scale in the definition to a figure for the adjusted consideration, which is contrary to the definition at clause 1.1 of the agreement, which requires an adjusted consideration to be calculated by reference to the consideration for the option. That's the first ground. Second ground, the expert has found that the four agreements constituted a single transaction, notwithstanding that they were between different parties and that there was no agreement to which all the participants were parties. Where two agreements are between different parties, they cannot, as a matter of ordinary English language, be a single transaction. This finding was also contrary to the definition of the qualifying transaction in consideration, which necessitated the sale and option being treated as different qualifying transactions. Now, the first complaint, as refined in oral argument below, is referred to, if you go over the page, to paragraph 64. See it's set out there. The first complaint is expressed in the Part 8 details of the claim at a relatively high level of abstraction and needs some unpacking. Mr. Downs clarified in his written and oral submissions that the gravamen of the complaint was that E20's calculation applied the percentage scale to two extrapolated 100% valuations of WHH. By this, he was referring to the point I made at paragraph 57 and 58 above. So that's the blending point. And that, again, is the main point that my learned friend takes in his skeleton for this appeal. In short, the learned judge identifies the point as being that it is not possible for more than one limb of the definition of consideration to apply to any given qualifying transaction. Can I just unpack that point before explaining why we say the expert's answer to that was neither an error nor a manifest error? The starting point is actually the definition of qualifying transaction. And the court will find that quoted in a helpful table produced by the learned judge at paragraph 33 of the judgment at page 75. if the court wants to look at it in the contract, tab 13, definition of qualifying transaction is at page 130. So qualifying transaction means any sale or transfer of any interest in the club, directly or indirectly by a relevant shareholder, including any sale of any interest in shares, right to purchase shares, share purchase option, or any transaction having the same or substantially similar effect. So it includes not only a sale, but also share options, etc. If I can then invite the court to look at clause 20.11, please, quoted paragraph 32 of the judgment, so just above the table. It's in the contract at page 179 behind tab 13. Subject to clause 20 and 2013, if the adjusted consideration is equal to or greater than the threshold amount, WHH shall, in respect of the payment of adjusted consideration payable on or about the date of the qualifying transaction, on or before the date falling 30 days after the date of the qualifying transaction, pay to E20 an amount equal to the stadium premium amount. And so as the court sees, what this is saying is that a stadium premium amount is payable if the adjusted consideration is equal to or greater than the threshold amount. And as the court will have picked up, it's common ground that the threshold amount is £125 million, and you see that at page 76 of the judgment, which extracts that. So at page 134 of the contract. An adjusted consideration, which is another expression that you see in clause 2011, means that, again, the court can see this, and the learned judge's helpful table at page 75, consideration plus certain adjustments relating to distribution and excess loan amounts for the qualifying transaction. And if the court's looking at the table on page 75, or the contract at page 117, you have the definition of consideration, which the court is familiar with, I know. Now, if you have one transaction, a transaction which is just the sale of shares or just an option, then the calculation is obviously straightforward. For instance, and I don't need to give you an example, perhaps I will. The total, if you have, suppose that the total issued shares in the company is 100, and there is a sale of 50 shares for £100. The qualifying transaction in that very simple example is the sale of 50 shares, and the consideration is to be calculated by applying limb B of the definition, because this is a sale of less than 100% of the club. What the contract says is that one has to extrapolate the value of the 100%, and the extrapolation is necessary so as to be able to make a comparison with the threshold amount, which is determined by reference to a transaction for 100% of the club for the purpose of identifying whether stadium premium amount is payable. So 50 shares are sold for £100 million, then the consideration is 200 million, because that is the amount that a sale of all 100 shares would have fetched if they had all been sold at the same price. And for simplicity, just assume that there are no adjustments to be made. In that event, the next step in the calculation is to go to the definition of the stadium premium amount, which is in the table at page 76, contract page 133. Stadium premium amount means the agreed percentage amount multiplied by the ratio A to B, where A is the share or rights to shares in the club that are subject to the qualifying transaction, and B is the total issued shareholding of the club. If you if you are looking at these definitions in the learner judge's table, then at page 76 you see the definition of agreed percentage amounts. That contains the ratchet provision. Depending on where you are in the ratchet will affect what percentage of your profit you have to pay on. And so in the simple example involving the sale of 50 shares for 100 million, the agreed percentage amount is the amount by which 200 million exceeds the threshold amount of 125 million. That would be 75 million, and that is the amount that you feed into the ratchet, and it hits it at different places. So 75 million, you would cap, the first 25 would be caught in the first part of the ratchet, and then the next 50 would be caught in the second part of the ratchet. So it's all very straightforward if you're just dealing with one element. Of course,
if the three sales have been at slightly different prices,
yeah,
would you would you then have added them all together?
Well, if they're different prices, you couldn't have added them together. You would have had to do, sorry, it depends what you're saying. You
Well, in
couldn't
the same
have
way,
added them
in
together.
the same way you add the option on at the end, would you actually have 4 elements all
You
added
would
up
have had
together?
4 elements. If the sale of the shares were at different prices, if there were 2 sales of shares at an identical price, then you could simply have added them together and then fed that through as a single qualifying transaction, even though you have actually added them
So
together.
if even 1 penny difference,
The formula wouldn't work. Your
but
denominator
it means
would be
that
different each time.
it means the share purchase amount is massively higher. Massively higher.
Well,
Just
I don't
because there's
know,
1
with
penny
respect, I'm not sure that the share purchase price is massively high. The share purchase price has been.
How you do, if you take the same approach that the expert
Yeah.
did, you don't get that result.
You don't get that result. It doesn't affect the share purchase price is no higher. The share purchase price is what it is in the contract. It's when you run it through the formula to work out what is produced by the ratchets that you add the outcome of the ratchets together. So one isn't changing the share purchase price at all. It always stays what it is in the contract. It's just what do you do for the purposes of when you identify a qualifying transaction which has more than one element, do you each time, when you evaluate running each element, do you each time look at one element and you ignore all the other elements for the purposes of seeing where you land up on the ratchet? Or do you realistically say, well, there are 2 sales here, they're getting all this consideration, I need to look at all of the consideration when I'm trying to work out how much
Well, each of the sales, because they're at the same price, it all ends up, whether you take them individually or cumulatively, the same result.
If it's at the same price, correct. If the price is different, you can't do that.
No.
You
And
have
then
exactly
the question is,
same-
but then the question is, what do you do with the results of those three
You're gonna have to-
exercises?
You're going to have to add them together in some way. You're going to have to, the word which has been used is blend the outcomes. So you're
But the
going to
way
have
that
to-
you blend, but the way that the expert blended the option with the sales was simply to add them on, simply add them together.
Well, he didn't just add them together. He first ran them through the contract and then added what you landed up with at the end. He added, once you extrapolated to 100%, he then added the outcome of that onto the sale.
Yeah.
But that didn't mean he was changing the price of anything. He was trying to identify, for the purpose of the contract, how you can work the formula.
Yes.
So he does add them on because, in his view, you were getting 2 considerations here, and therefore you should add them on.
Yes.
Not changing the purchase price of
But then
anything.
what I don't understand is if there are 3 different prices for the 3 different sales, why doesn't that logic apply too, and you're getting 3 different considerations?
It would apply. Indeed, it's my case that it would apply, unless the price is the same. If the price is the same, then it's very easy. You just add them together. Let's say you have a sale of 100 shares at £50 and a sale of another 100 shares at £50. Then effectively you've got a sale of 200 shares at £50 per share. If you've got the sale of 100 shares at £50 and the sale of 200 shares at £49, you can't do that.
But if the other shares are sold at $49.99, you're getting pretty much the same amount
But you're,
of consideration,
well,
but
then
the
I'll
result
say they're
is
sold
different.
at £45 and that 100 shares at £105 and another lot of shares at £45. I mean, it has to cater for all possibilities, this. And it doesn't cater for any possibilities other than treating...
But I think Mr. Downes's point then, he says, well, in that case, it's a nonsense to talk about it as one qualifying transaction.
But with respect, it is one qualifying transaction. It could be between the same parties and one single contract in which you have a sale to subsidiary X of 100 shares at £49 and a sales to subsidiary Y of the same amount of shares at £51. There you would still have to blend. There's no way around it. But on Mr. Downes's case, you would run those through together, separately, and you'd find yourself being able to avoid the stadium premium amount because they've split the amount of shares being sold. I'm not saying his clients did this, but the construction for which he contends would lead to the result that you could structure things in a way to avoid the application of the stadium premium amount.
Well, you can do that. You can do that.
That's the key point, though, isn't it?
That is the key
That-
point.
That whether by partial sales or sales at different prices in one overall transaction, you look at them individually and say they're each under the threshold.
That is the key point.
That's the key point.
That is the key point, and that is what the judge plainly didn't think was right. So in the end, you have that problem of structuring. My learned friend says these are sham transactions. They're not. I mean, you could structure, as I said at the outset, you could have a sale of 100 shares at £50 each, or I could sell 50 shares at £50 and then have an option agreement where one way or the other I'm going to get £50 for it. In my learned friend's case, rather than having a sale of 100 shares at £50 each, I have two £50 share options, neither of which will hit the threshold.
Well, any of these three sales could have been structured as an option.
Completely. You could structure it in very many ways, and you effectively could work your way, you could produce outcomes which prevented the threshold amount being established, a hit. Even though it's part of one transaction, plainly part of one transaction. I think one must not be misled by the fact that in this transaction there were two separate contracts because they were plainly linked. And I don't
But
think.
why, forgive me there, but why would it prevent the threshold being met? Because the threshold will be met in relation to any one of the sales transactions.
That depends. It depends on what the sale transaction is, what the values of the sale transaction. Let's say the threshold is 125 million.
Yes.
And let's say that one way of actually selling 100 shares at £100 each. Does that hit the right amount? Or £1,000 each? It doesn't really matter. So I go way above. If I structured it in a particular way, I go way. If I just had an ordinary transaction with one single element, I'd go way above the threshold. What I do is to break that transaction into two, have a sale transaction for an amount of shares which does not get to the threshold, and an option agreement, which again, looked at it on its own, does not get to the threshold. And that way I avoid paying any stadium premium amount.
The concept of avoidance here doesn't seem to me is particularly helpful because these are consensual sales. So each party is able to negotiate to, and what you're saying is that the shareholders could. But the thing is, it's the company that pays the premium, isn't it?
It's the seller.
Not
the company. That's correct.
It's not the shareholder or the purchaser that pays the premium, is it? It's the company.
I'm not sure that's right. If my learned friend, if my lord is asking me whether the Gold and I can't remember the name of the other shareholder, what's it called? Sullivan, could have been involved in a sale to a third party where they had the ability to say to a third party, look, we have a contract with E20. If we have one transaction at this amount, we're going to hit the threshold and we're going to have to pay the money. Could we, as between ourselves and you, break that into two bids? The answer is yes, they could.
Yes, I see.
And that is the issue here. That is what the learned judge, I don't know whether no one was saying that.
No, nobody's saying, you're not saying that. This is just an example of how it works.
It's an example of how it works and how unlikely it is that for the purpose of a qualifying transaction, where you had a qualifying transaction which had two elements, you had to evaluate them separately.
Well, you see that from the examples, Rich. It doesn't matter whether you have three
Those
sales or one.
Those are all at the same price, so one needs to be careful about that example.
I understand that.
Let's see where in my note we are. So we have this qualifying ground point. Yeah. I think one needs to go back just to look at what the learned judge said. If you go to paragraph 66 of the judgment, you see that the learned judge there is dealing with the definition of consideration. It says self-evidently covers 3 alternate transaction types. The use of the disjunctive or shows that consideration may mean any one of 3 things in relation to a given qualifying transaction. There is nothing in the wording of the definition that indicates that consideration may mean any one or more of the 3 alternatives for any given qualifying transaction. And then proceeding on that premise, if you look at paragraph 67, the learned judge there says that our approach can be justified only if there are words elsewhere in the contract that justify it. And then if you go to paragraph 84(1) on page 88, you see that the learned judge says that the expert's determination was not only wrong, but manifestly wrong, because as the learned judge puts it at the top of page 89, he said the expert, this is his language, took the drastic step of mutating a disjunctive word into a conjunctive one. So a great deal of reliance was placed by the learned judge in finding a manifest error on the word or. There's this terrible thing where you took a drastic step of mutating a disjunctive word, that's the or, into a conjunctive one. Now, we respectfully submit that there are at least 4 problems with that reasoning. The first is the learned judge's apparent assumption that the word or can, apparently whatever the context, only be disjunctive and never conjunctive. Indeed, so much so that he considered that to read it conjunctively would be a drastic step that involves mutation. But with respect to the learned judge, that is not the position. If the statute or contract says A or B, that sometimes means either A or B, but not both. And sometimes it means A or B or both. And whether it is one or the other depends on the context. And indeed, Benyon suggests that the normal meaning is actually the latter, not the former. That is to say, A or B or both. Can I just very quickly show the court Benyon? That's at tab 15, the authorities, beginning at page 265, although the relevant passage is section 1711, page 283. So there, the words all and can be used in different senses, and this can occasionally give rise to difficulty where it is not clear from the context what sense is intended. The word all is normally used in an inclusive, so that A or B means A or B or both, although it can also be used in an exclusive sense, so that A or B means A or B, but not both. And then over the page, he says, just looking at the comment, in most contexts, the sense in which A or B are used will be apparent from the context and the application of basic common sense, but they occasionally give rise to doubt. It has sometimes been suggested that in legislation the word or is more often used in an inclusive sense, and that and is more often used in a joint and several sense. That is a useful starting point, but it may be displaced by context. And then he then gives an example from a case called Pillings and Reynolds, where it was used in an inclusive sense. Now, I appreciate Benyon's about statutes. It's not about contracts. With respect, it's difficult to see why the position in contract should be any different to statute. And for ourselves, we can't see why it should make a difference. And of course, the court will also be familiar with the authorities in the context of contractual interpretation that indicate, for example, that the word and in a contract is sometimes used in a conjunctive sense, and sometimes in a disjunctive sense, and that it all depends on context. I'm not sure I need to cite authority for that proposition, but one example for the court's note is the judgment of Lord Justice Fox in a case called Price and Ferguson. It's not in the bundles, but we can make it available if the court would like to see that. So that's the first problem with the learned judge's analysis. He appears to have been absolutely convinced that the word "or" was the complete answer to why the learned judge joined. In effect, that word used in that context simply does not bear the weight the learned judge put on it. The second problem with the learned judge's analysis is this. This goes to the fact that the learned judge did not really grapple with whether his interpretation of the word "or" made commercial sense. Indeed, it is, we submit, notable that neither paragraph 66 to 71 of the judgment, nor paragraph 84, which are the paragraphs that deal with this point in the judgment, refer at all to the commercial purpose of clause 2011. Rather, they are concerned purely with the learned judge's analysis of the language of the contract. But as the court may recall, it's common ground between the parties that the share sale and the option, in this case, are at least in a commercial sense linked transactions, and that it was obvious and not disputed that the shareholders were acting in concert in the sale of the shares, and that the option agreement was closely linked to the sale and part of the same arrangement. And just pausing there, and this is traversing a point I think I've already traversed, if the judge is right, the learned judge is right, it is possible for the seller to reduce the amount of the stadium premium amount by the simple expedient of using inflated call options. Assume, for example, that the shareholder finds a purchaser who's willing to pay 100 million for 50 shares. If they do a share sale for 100 million, then the consideration would be 200 million, which is obviously 75 million more than the threshold amount of 125 million. And a stadium premium amount would be payable. But the parties, in order to avoid that, could decide instead to sell 50 shares for 50 million instead, and to grant an option in respect of the remaining 50 shares for an option premium of 50 million, agreeing that the amount payable upon exercise is a nominal amount, say 50 pence or £1. In that event, the shareholders will receive the same £100 million, shareholders, and part with the same number of shares. So they sell 100 million, they get 100 million and they part with the same number of shares, but they avoid paying the stadium premium. Simply because on the learned judge's approach and my learned friend's case, one treats the share sale and the option as separate qualifying transactions, each of which has to clear the threshold amount separately. And in the example I've given, neither would. That, we would suggest, would plainly be contrary to the commercial purpose of clause 2011, which you will recall is to enable a public body to participate in profits realized by the shareholders, not to facilitate the shareholders being able to structure their way around that obligation by splitting qualifying transactions into two elements. Now, as the court may have seen, my learned friend's answer to this point, certainly in his submissions below, or at any rate to the expert, involved what he called the anti-avoidance point, and that was that such agreements might be treated as a sham. That is in his defense at paragraph 7, supplemental bundle. I'm not inviting you to go to there now. Supplemental bundle, tab 2, page 11. With respect to my learned friend, that does not work, because in the example I've given of the sale of 50 shares and an option over the remaining shares, the parties intend their legal obligations to be as set out in the documentation. There is genuinely an intention to grant an enforceable option to be exercised, albeit for the cost of only £1.
Is it right that in that example, if you split the sale in the way you suggested, neither half of it would reach the threshold?
Yes.
But don't they both imply the same ultimate consideration for the company? Just the fact because if you sell 100 shares at a price,
Right.
you're looking to see what the implied value of the company from that.
Right.
If you sell 50 shares at the same price, don't you reach the same implied value for the company?
With respect, I don't think you would, because if you're selling 50 shares at that price
Price per share.
You would actually.
Whatever the price per share, you reach the same implied value
I
for the
think
company.
your example should be, your second example should be selling 25 shares and granting an option over a further 25, because otherwise you commercially end up selling the entire company.
My lady may be right. May be right.
Which may be confusing matters.
But to go back to where I put it, if it does reach if you do have the same implied value for the company, however many shares you're selling, and what matters is the price per share. The danger is if you split it and reach the implied value for the first part of the transaction, implied value for the second part, and it's the same implied value, and then add them together, you're doubling.
That's the point I was making earlier about the 3 tranches of share sales.
But if you're selling shares may be a problem. It might not be a problem if what you're doing on the one hand is selling shares, on the other granting an option which is in fact never exercised, because it's not surprising you reach more than the value of the company.
Well, maybe that would have been a better example. I grant an option which is, in a way, that may be a better example. So I sell shares, 50 shares, and I grant an option for the remainder of the consideration on the basis that it will not be exercised, or knowing that it won't be exercised. In that way, you still get to avoiding the threshold amount being hit. And my lord is right in terms of, with respect, right. I accept that. And we respectfully submit that there is no satisfactory answer to the anti-avoidance point that we raise. And that the very fact that the learned judge's construction gives rise to this problem is a good reason for not adopting the learned friend's approach. At a minimum, my lady, my lords, even if my learned friend is right about the possibility of some transactions being struck down as shams, it cannot be a manifest error not to adopt that construction. And that is, we say, the second difficulty with the learned judge's construction. Third, there is another reason why the learned judge's approach does not, with respect, make commercial sense, and it is this. If you can go back, please, to the ratchet provision in the contract, page 112, in the judgment at page 76. As the court will recall, the percentage of the agreed percentage amount payable increases as the consideration rises. In other words, the greater the profit above 125 million, the higher the percentage that applies in reaching the stadium premium amount, and so the greater the share given to the public authority of the profit made. And so by way of another example, if the consideration is below 125 million, nothing is payable because the threshold amount has not been crossed. If it is between 125 and 150 million, the applicable percentage is 7.5%, as you see. But for the slice of the consideration between 150 and 200 million, it's 10% and so on. And that reflects the obvious intention that the greater the profit, the greater the share that should be handed over to the public body by way of overage. Now, against that background, if one then considers the learned judge's approach, a composite transaction containing different types of transfers, such as a share sale and an option, in his view, will always constitute separate qualifying transactions, each of which must clear the threshold amount separately. And so on that approach, even if both elements do separately clear the threshold amount, such that some premium amount is payable, the inevitable consequence of the learned judge's approach is that the amount payable will be lower than it would otherwise have been, because it will become more difficult to access the higher level of the transaction, of the ratchet. And the reason for that, as the court will have discerned, is that each component has to clear the threshold amount separately. And so once you've done the calculation for one component, you have to start afresh with another component, which makes it more difficult to access the higher levels of the ratchet. If, by contrast, the composite transaction is treated as a single qualifying transaction, so that when calculating the consideration received, one has regard to all aspects of their qualifying transaction taken together, then one is more likely to get to the higher levels than one would if one was required in all circumstances to treat them as separate.
Well, all of this seems to me only has form and significance in relation to an unexercised option with a payment option price. That's where the problem arises on both sides.
Yeah. that may be fair.
And what happens as a result of it is either on your case, on your criticism of Mr. Downes's approach, either the shareholders get a consideration for which is not included in the calculation, or in Mr. Downes's case, you get a blended result which doesn't mirror the value of the company. Neither way does it actually work properly, and that goes right back to the beginning, where this clause doesn't work for option prices.
Yeah.
And you said your answer to that is, well, there we are. That's the difficulty that the parties had. They put that to the expert, and the expert came up with his answer. And it may not be perfect, but it's a perfectly demurrable result.
It's not perfect. It may not even be as imperfect as my learned friend's approach. But is there no argument at all? Is it obvious and unarguable? Because if it isn't obvious and unarguable without spending any time looking at it, you may think that the learned expert came to the wrong conclusion, but that is not the point. You're not sitting on an appeal. And that really was the fourth point I was going to make, which is, it's one thing to say he went wrong, and leave aside the or point, where in my respectful submission the judge was plainly wrong and the expert was plainly right. What do you do about blending? The expert thought you should blend because you shouldn't be in a situation where you have to treat the qualifying transaction, every element separately. Now, he thought you should, therefore blend. Miller and Friend says you shouldn't. The judge thought you shouldn't. Plainly, there's an argument to be had, and I'm not saying there is no argument.
Well, what you say, as I understand it, is if the parties devised an imperfect mechanism and then left it to an expert to decide how that should be operated, it's very hard to say afterwards that it was a manifest error when you did exactly that.
In short, it could have been a lot shorter. That is what we say. My lord and my lady, given the time, and in order to leave myself some time for reply, I'm going to, subject to the court, stop there.
Thank you very much. So, Dan, do you want to have a 7 or 8 minute start? You might as well.
It's more than that, actually. That watch is wrong.
Oh, that watch is, yes, that clock is about 8 minutes.
Oh, yes. In fact,
so
you've got
far.
nearly a quarter of an hour, in fact.
Lord, my lady, our position is that this is a simple case. A contract provided a pricing mechanism. That's not an uncommon type of contractual provision. And the pricing mechanism was in the form of a formula, a mathematical formula aimed at, it is common ground, calculating an overage sum. There is no dispute about the inputs for the formula. All of those figures were common ground before the expert, the judge, and before this court. All that was left was for the expert to do the sum. That is to say, to apply that formula to the agreed input figures.
Well, forgive me, is that really right here? Plainly, the end result is you have a formula, but haven't you got to interpret what a qualifying transaction is, and haven't you got to interpret what consideration is? It's not simply a matter of a straightforward equation in which you just plug the figures, have you? There's some interpretation to be done.
Well, there is some interpretation to be done, I accept that. But it's only interpretation of what was intended to be a contractual formula.
Well, yes, but in a sense, most contracts which end up with one person paying money to the other may produce a formula, but you have to interpret what the contract means first.
I accept that. There was no dispute between the parties that these were either viewed separately or together, a or two qualifying transactions. There was no dispute about that. There was no dispute about the consideration small c that was paid by each side. What one was left with was a mechanism in the contract to feed those figures into, and I agree the application or interpretation of that mechanism was a matter that the expert embarked upon. But our position is he just got the sum wrong. That's what happened.
Well, there's no real argument about what the sums are, is it? It's really the two of you do it different ways, and it doesn't depend upon it. No one's saying anyone got the maths wrong. It's the question is is it one or more qualifying transaction? And if it's one qualifying transaction, how do you work out what is the consideration, looking at the definition there? So it's all about interpretation, really, isn't it?
Can I develop the point?
Yes, of course. Sorry.
Well, of course, any reading of words in a document and then giving effect to those words involves some interpretation. But some interpretations we would submit are just outside of the range available to the expert. But whether it falls within that category of case where the expert's simply interpreting arguable meanings of words, which my learned friend says, or whether it's that category of case where the meaning is clear and the area is clear cut, is a matter obviously for this court, for your lordships. But we say it's clear cut. It doesn't matter which adjectives one attaches to it. Manifest error, unarguably wrong, obvious error. We say that we satisfy any of those.
Yeah.
That one cares to apply. And this formula was, I accept, moderately, but it's not terribly complicated when one gets into it and understands how it works. And the expert clearly, we see from the note, struggled with the formula, and he got it wrong. And the expert, his decision was subject to scrutiny by the judge, who, with considerable care, mindful of all the authorities, found that the expert's answer was unarguably wrong. And we've conceded before the judge, I concede before this court, we've conceded throughout, that if this formula is ambiguous, i.e. it is open to one or more than one interpretation, then I must lose. I must lose either before the judge or before this court, because I do accept that the interpretation of ambiguity was a matter solely for the expert. But if I'm right that the formula is unambiguous, clear, then it must have only one right answer. And if the expert didn't arrive at that answer, it must be wrong, and it must be manifestly wrong. Now, I had 4, but I've added a heading, so 5 headings. Firstly, I'll look at the formula. Secondly, the determination. It's a convenient way of answering some of the points made by my learned friend. Thirdly, business common sense. Fourthly, some observations on the cases. And then fifthly, just some specific answers to some of the points made by my learned friend. So, first heading is the formula itself. I've got it marked up in the concession agreement, which is in the core bundle at tab 13. The starting point is common ground is clause 20.11. This is the operative obligation to pay money. And clause 20.11 introduces us to 4 defined elements, none of which is readily apparent from the face of clause 20.11. it says subject to 2012 and 13, which don't apply. If the adjusted consideration, that's the first defined clause term, is equal to or greater than the threshold amount, that's the second, the concessionaire shall in respect of payments of adjusted consideration, that's the third, payable on or about the date of the qualifying transaction. It's always common ground that these were qualifying transactions. On or before the date falling 30 days after the date of the qualifying transaction, pay to the grantor an amount equal to the stadium premium amount. So the four terms we have are the adjusted consideration, threshold amount, qualifying transaction, and stadium premium amount. But we can observe straight away that the clause, the obligation to pay money, is only engaged if something called the adjusted consideration is equal to or greater than the threshold amount. And if that condition is satisfied, there is an obligation to pay something called the stadium premium amount. So taking those in turn, starting with qualifying transaction, we've looked at it, don't need to look at it in any detail, but that's at page 130 in the core bundle, towards the bottom of the page. It is any sale or transfer or any interest in the club, directly or indirectly by a relevant shareholder. And as I say, it's common ground, that's satisfied. The next thing is to look at this adjusted consideration. And that is at page.
Forgive me, you say it's satisfied, and obviously that's common ground between you, but there is an important question as to whether it is one or more.
There is more.
More.
There is.
So can you just move on from that so quickly? It's
Well, Lord, what we've said, what we always say about that, is that commercially we accept that this may be viewed as a single transaction. And therefore, in that sense, commercially may be seen as a single qualifying transaction. But that when one comes to the formula and feeding the figures into the formula, that does not mean that you double count the elements of consideration. I made that clear before the expert. He was wrong to say it was common ground that that point was determinative, and I'll show your lordship, your ladyship, that in due course. Adjusted consideration is at page 110, and adjusted consideration means the consideration, capital C, plus the aggregate of distributions and excess loan amounts. That's not an inconsequential point, because these definitions, they're not merely definitions, they are also, as I've said, defining a process of mathematical, the manipulation of figures. And so would you just note, my lady, note that the consideration is adjusted once by distribution and excess loan amounts. And I think it's common ground that that is intended to reflect an adjustment whereby if the shareholders have extracted value from the company before the sale, there should be some allowance made for that. So, for example, if one took out huge dividend just before the sale, such that the share price was depressed, one adds back the dividend, the excess loan amounts and the like, in order to provide an adjustment. But that's
Does the fact that you have to do that give us any indication as to whether, for example, we should be reading qualifying transaction is broken down into several qualifying transactions in this case, or one single qualifying?
It does, because there's no logic to carrying out that adjustment once. If you're going to go down the blended approach, there's no logic to simply doing the adjustment once. You'd presumably have to do it twice. Um,
And it was only done once here, in fact.
only once in August.
But it could have been done twice.
Could have been. There's a lot of things that could have been done in this case that show how wrong the expert's approach is. But in this case, it wasn't done.
Why is there no logic to doing it once? Because it's a separate element which you're having to add back in. Why isn't that?
Because
Then only
well,
once.
we're sort of going to come to it, but the consideration capital C is the notional value of 100% of the company. So if you're going to say the logic being the notional value of 100% of this company is, take a figure, 200 million. But shortly before the transaction, or indeed any point, additional value was extracted to the tune of 10 million. There's a logic to saying we add the 10 million to the 200 million. There's not really much logic in saying, well, we're going to double the notional value. We'll have the notional value by reference to a disposal and the notional value by reference to a share option. We'll add them together, but we'll only do the adjustment once. That's
Well, it doesn't matter whether you're adding them together or not. There's no reason not to include those elements in a calculation of the notional value of the company, however you're,
yes, I agree.
at whatever stage you're arriving at it.
I agree with that. I agree with that. It's not the main point, but it does. It's consistent with what we say this formula was directed at. And in my submission, once one understands how the formula works.
But the trouble is that when you're looking at the option price, you're not looking at the value of the company on any basis. So we're way off beam to start with.
I don't accept my learning friend's point in that respect, but it's easier if I deal with that when we look at the individual elements. But of course, an option price is likely to be less. But when the parties entered into this contract,
Well, one can see here it notionally ascribed the company a value of 60 million.
yes, but when the parties
That's not what anyone thinks is sensible. That's just
when the parties enter into the concession agreement in 2013, they don't know what option prices may be over the ensuing 10 years qualifying period. Could be that options would be such that they'd be worth more than 125 million. Depends as well what the strike price is.
no, but it doesn't matter whether they're worth more than 125 million. It matters whether or not they are equivalent to the value of the company.
But the way the formula works, I think it will be more helpful if we do it in stages, but the way the formula works is to trigger the stadium premium amount calculated by reference to what 100% of the company would be worth, and then prorate it down. That's how it works. Can we take
Come back at 2 o'clock on that? Yes, very well. Thank you very much.
All rise if able.